If you've got a specific legal question or situation you'd like to see covered here, drop it in the comments, because that's genuinely where a lot of future topics come from. I read them, and some of the most useful specific videos on this channel started as exactly that kind of comment from someone dealing with a real situation, so don't hesitate. Whatever it is, I'd like to hear it. All right, let's keep moving. You're driving. Maybe you've been on the road for 20 minutes, maybe 5. The radio's on, traffic's moving, you're thinking about wherever you're headed, and not much else, and then you see it in the rearview mirror. Lights, blue and red, and they're for you. Your stomach does that specific thing it does. You pull over, you roll the window down, and then comes the sentence that stops a lot of people cold. The one that doesn't get covered in driver's ed. The one most people have genuinely never thought about before this exact moment. Step out of the vehicle, please. And right there, in the space between hearing that sentence and deciding what to do with it, most people get it completely wrong. Not because they're reckless, not because they're trying to make trouble, but because nobody ever actually sat them down and explained what that sentence means, legally, what you're required to do, what you're not required to do, and how the next 60 seconds of that interaction can shape everything that follows. The decision most people make in that moment is based on instinct and assumption rather than anything they actually know, and instinct and assumption are genuinely terrible guides for a moment with real legal stakes attached to it. Here's what I want you to walk away from this knowing so well you don't have to think about it under pressure. Being ordered out of your car is not the beginning of the end of your rights. It's a specific, defined moment in a specific, defined legal framework, and that framework has rules, rules that protect you, rules the Supreme Court itself has weighed in on directly, rules that have been tested in real courtrooms with real consequences. And once you actually understand those rules, that moment stops being terrifying and starts being something you can navigate clearly, calmly, and intelligently every single time. Before we get into exactly what the law says and exactly what you should do, if you want to actually understand your rights instead of hoping for the best every time you see lights in your mirror, subscribe right now, because that is precisely what this content is built to give you. And a quick note before we get into it, this is legal education and commentary, not legal advice for your specific situation, and some details vary by state, but the core principles we're about to walk through are grounded in Supreme Court decisions that apply everywhere in this country. Now let's get into it. Let's start with the foundation, the single most important legal fact that underlies everything else we're about to cover, because without it, none of the other rules make complete sense. When a police officer tells you to get out of your car during a traffic stop, you are legally required to comply. That's not a maybe, it's not a gray area, it's not subject to interpretation based on how you feel about the stop or whether you think the stop itself was justified. You must get out of the car when an officer orders you to do so. Full stop. That rule comes directly from the Supreme Court of the United States, in a case called Pennsylvania v. Mims, decided in 1977. The facts of that case were straightforward. A driver was stopped for an expired license plate, and the officer asked him to step out of the vehicle, and the driver did. And when he did, the officer noticed a bulge under his jacket that turned out to be a weapon. The driver was convicted, he appealed, and the case worked its way all the way up to the Supreme Court, which ruled that an officer conducting a lawful traffic stop may, as a matter of routine, order the driver to exit the vehicle, and that this does not by itself violate the Fourth Amendment, which is the amendment protecting against unreasonable searches and seizures. The court's reasoning in Mims came down to a balance. The government's interest in officer safety during a traffic stop is real and significant. Officers are statistically more vulnerable during traffic stops than almost any other routine law enforcement encounter, and removing a driver from the vehicle reduces certain specific risks associated with keeping them inside it, specifically the possibility of them reaching for a weapon while seated in a confined space where the officer has limited visibility and limited options. I want to talk for a second about why I think content like this actually matters, beyond just being interesting to talk about. There's a real meaningful gap between people who have easy access to legal knowledge, whether through education, profession, or family background, and people who don't, and that gap has real consequences in real situations. It's not fair, and it's not something any individual video is going to fully fix, but I do think there's genuine value in narrowing that gap even a little, one plain language explanation at a time, for anyone willing to spend a few minutes actually learning something instead of relying on guesswork or half-remembered fragments picked up secondhand. That's the actual mission behind this, as unglamorous as that sounds. Not to turn anyone into a lawyer, but to close the specific, practical gaps that leave ordinary people at a disadvantage in moments that matter. All right, let's keep working on exactly that with today's topic. That governmental interest, the court said, outweighs the relatively minor inconvenience imposed on the driver by being asked to step outside. And then, 20 years later, the Supreme Court extended that same principle in Maryland versus Wilson in 1997. The Mims case had established the rule for drivers. The Wilson case answered the next obvious question: what about passengers? The court said the same rule applies. An officer conducting a lawful traffic stop can order passengers to exit the vehicle as well, not just the driver, and that order must be complied with. The same balance of interests applies. Officer safety outweighs the minor intrusion of being asked to step outside a car during a stop that's already legitimately underway. So there it is, from the Supreme Court itself, clearly and directly, both drivers and passengers can be lawfully ordered out of a vehicle during a traffic stop, and the proper response to that order is to comply. This is not an invitation for a debate on the sidewalk. This is not a moment where you explain your view of whether the stop was valid. This is a legal command that carries the authority of a Supreme Court ruling, and the correct, complete response to it in the moment it happens is to get out of the car. But here's where it gets genuinely important, because that's where a lot of people think the story ends, and it doesn't end there at all. What happens after you exit the vehicle is a completely different set of questions, governed by a completely different set of rules, and knowing those rules is every bit as important as knowing the first one. The obligation to step out of the car when ordered doesn't mean the officer then has unlimited authority to do whatever they want. Not even close. Your rights don't evaporate when you step out of the vehicle. They come with you onto that curb, and some of them are actually stronger outside the car than they would have been inside it. Let's walk through exactly what happens next, step by step, because the sequence matters here just as much as the individual rules do. The moment your feet hit the pavement, the stop continues under exactly the same legal constraints it operated under before you got out. The officer's authority to detain you is still based on the same reasonable suspicion or probable cause that justified the stop in the first place. The stop still needs to be completed within a reasonable time and scope. In other words, officers can't just manufacture reasons to keep you standing there indefinitely while they try to find something wrong. If you were stopped for a broken taillight, the investigation of the broken taillight is what's legitimately underway, and the scope of everything else that can happen during that stop is constrained by that underlying purpose. This is a principle the Supreme Court reinforced more recently, in Rodriguez versus United States in 2015. That case established that officers cannot extend a traffic stop beyond the time reasonably necessary to address the reason for the stop itself, without having independent reasonable suspicion of some separate criminal activity. So if the stop is about a registration issue, the officer handles the registration issue, runs the relevant checks, and the encounter ends when that's resolved. They can't keep you standing there for another 20 minutes, fishing for something else, without a specific, articulable reason to suspect something beyond what the stop was originally about. Understanding this principle matters, because it frames everything that comes after you step out of the vehicle. You stepped out because the law requires you to. But the law also limits what the officer can do with you once you're out there, and understanding those limits is exactly what keeps you from inadvertently giving away rights you didn't realize were still yours to assert. Let's talk about what stepping out of the vehicle actually looks like in practice, because the how matters here almost as much as the what. When an officer orders you out of the vehicle, move slowly and deliberately. This is not the moment for quick movements, and it is not the moment for anything that could be interpreted as sudden or unpredictable. Tell the officer what you're doing before you do it if you need to reach for anything at all. I'm going to reach for the door handle. Sounds overly literal written down here, but in the actual moment, calm, deliberate narration of your own movements is one of the most effective tools available to keep an already tense situation from escalating in a direction that doesn't benefit anyone. Keep your hands visible throughout this process. When you exit the vehicle, hands come out first or at least remain clearly visible. Don't reach under the seat. Don't lean over to grab anything from the center console. Don't make any movement that isn't part of the simple, direct process of stepping out of the car and standing beside it. If you need to grab your license, registration, or insurance card before you exit, ask first, "Is it okay if I get my license from the glove compartment before I step out?" That question costs you nothing and creates a moment of clear communication that benefits everyone in the encounter. Once you're standing outside the vehicle, plant yourself near the side of the car, out of the lane of traffic, in a clear, open position. Don't lean back into the vehicle. Don't reach back inside. Don't wander away from the car. Stand there, calmly, clearly visible, hands at your sides or in front of you, and wait for the officer to direct the next part of the interaction. Now let's talk about what you're not required to do once you're standing there, because this is where a huge number of people give away enormously important rights in the first 60 seconds after stepping out of the vehicle, often without even realizing they're doing it. You are not required to answer questions beyond identifying yourself, and even the identification requirement varies by state. Many states have what are called stop and identify statutes, which require you to provide your name or identify yourself to an officer who has reasonable suspicion that you're involved in criminal activity. But even in states with those statutes, providing your identity is usually the extent of what's required. You're generally not required to explain where you're going, where you've been, whether you've had anything to drink, what you have in the car, or to provide any other information in response to the officer's questions. The right to remain silent exists outside the car just as clearly as it exists inside it, and stepping onto the curb doesn't change that. What this looks like in practice is something worth having in mind before you ever need it, because improvising polite ways to decline answering questions while standing nervously next to a patrol car is a lot harder than it sounds. Something like, "Officer, I'd rather not answer questions right now, but I'm happy to wait while you complete the stop," is a complete, respectful, legally sound response to almost any question beyond a request to identify yourself. It's not aggressive, it's not accusatory. It's a calm, clear invocation of a right you're entirely entitled to invoke, delivered in a way that keeps the tone of the interaction as calm and cooperative as possible, without you actually cooperating in ways that could work against you. Let's talk about something specific that comes up constantly in traffic stop encounters. The question about whether you've had anything to drink. This question comes packaged to feel routine, almost conversational, like it's just something officers ask as a matter of course, and the packaging is deliberate, because the conversational framing is specifically designed to make answering feel natural and expected, rather than potentially significant. But your answer to that question, whatever it is, can become part of a legal record in ways that may matter significantly later. "I'd rather not answer questions about that" is a complete, legally sound response. So is a polite, "I'd prefer to exercise my right to remain silent on questions like that." Neither of those responses requires you to be combative, and neither of them is the same as admitting anything. It is simply declining to participate in a voluntary portion of the encounter, which you are entirely allowed to do. Let's talk about searches now, because this is where the encounter most commonly pivots from a simple traffic stop into something with much larger potential consequences, and the rules here are genuinely worth understanding in detail. Standing outside your car does not give an officer the right to search your car. The fact that you've exited the vehicle doesn't change the Fourth Amendment's requirements around what justifies a search. A lawful search of your vehicle generally requires one of a few specific things: your consent, probable cause to believe the vehicle contains evidence of a crime, a warrant, which is rare in the roadside traffic stop context but theoretically possible, or some other recognized exception to the warrant requirement, like a search incident to a lawful arrest. Let's go through each of those, because understanding them separately is what lets you respond appropriately when one of them is actually what's happening versus when an officer is simply hoping you won't know the difference. Consent is the most common pathway to a vehicle search in an ordinary traffic stop, and it's the one most entirely within your control. If an officer asks, "Mind if I take a look in your car?" or "Do you have any objection to me searching the vehicle?" or any variation of that question, those are invitations, not commands, and the legally correct response to an invitation is either acceptance or declination, not compliance, simply because someone in a uniform asked. You are allowed to say no. You are allowed to say, clearly and calmly, "I don't consent to a search of my vehicle." That sentence doesn't mean the search won't happen. It means it can't be justified by your consent if it does happen, which is enormously significant in any legal proceeding that might follow. What you're not doing when you decline is admitting that there's something in the car. You're not doing anything suspicious. You're not creating legal trouble for yourself. You are exercising a specific, clearly established constitutional right in a situation specifically designed to protect you, and the proper exercise of that right is not evidence of anything at all. Officers are required to know this, and many will move on when you decline. Some won't. If the search happens anyway, your clearly stated non-consent is something an attorney can work with. If you said yes, or said nothing, or gave an ambiguous response that could be characterized as consent, that same attorney has considerably less to work with. Let's talk about probable cause, because this is the exception that gets invoked most often when an officer wants to search a vehicle without your consent. Probable cause means the officer has specific, articulable facts that would lead a reasonable person to conclude that evidence of a crime is probably in the vehicle. The smell of marijuana is one that comes up constantly in case law, though this particular one is increasingly complicated by the expansion of marijuana legalization in various states, and whether the smell of marijuana alone constitutes probable cause for a vehicle search is an area where the law varies significantly by jurisdiction and has been evolving relatively quickly. Plain view of contraband or evidence is another. If an officer can see something in the vehicle that's clearly illegal, that observation alone can establish probable cause to search further. The critical thing to understand about probable cause is that it's not something that gets manufactured by your behavior in a voluntary encounter. In other words, if an officer doesn't have probable cause before asking you whether you've had anything to drink, your refusal to answer that question doesn't create probable cause. Your declining a consent search doesn't create probable cause. The assertion of your constitutional rights is not, by itself, evidence of criminal activity, and no court in this country has held that it is. This matters because you may feel, in the moment, that declining to consent or declining to answer questions is somehow feeding the officer's suspicion, and the officer may even say something like that directly. Something like, "If you have nothing to hide, why won't you let me take a look?" The answer to that question, in whatever words feel most natural to you, is simply that exercising your rights isn't evidence of anything, and you'd like to do exactly that. You're allowed to hold that position firmly and calmly, regardless of how the question is framed. Let's talk about the search incident to arrest exception, because this one is worth understanding in some detail, specifically because it gets invoked at the point in an encounter where stress is highest and thinking clearly is hardest. If you are placed under arrest, officers may have the authority to search the area within your immediate reach, which in the vehicle context has been substantially narrowed by the Supreme Court in a case called Arizona versus Gant, decided in 2009. Before Gant, the search incident to arrest exception was interpreted so broadly that officers could essentially search your entire vehicle whenever they arrested the occupant. After Gant, the rule changed significantly. A search of the vehicle's passenger compartment incident to arrest is only valid when the person being arrested is unsecured and within reaching distance of the passenger compartment, or when it's reasonable to believe the vehicle contains evidence relevant to the offense of arrest. What this means in practice is that if you're placed in handcuffs and seated in the back of a patrol car, the search incident to arrest exception no longer gives officers blanket authority to search your vehicle simply because you've been arrested. The situation is more constrained than that, and the constraints exist specifically to prevent the arrest from becoming an automatic green light for an unlimited vehicle search. If your vehicle gets searched after your arrest in circumstances that don't fit within these boundaries, that's exactly the kind of thing an attorney can examine and potentially challenge after the fact, which is why maintaining a clear record of what happened, in what order, with what stated justification, matters so much in the moments when it's happening. Let's talk about what to actually say during this encounter, because I want you leaving this with specific sentences ready to go, not just a sense of the general principles. The principles matter, but the specific words you say in the moment, delivered calmly and clearly, are what actually operationalize those principles in the real encounter. If an officer orders you out of the vehicle, you comply, calmly, slowly, deliberately, hands visible, narrating any movements you need to make to exit the vehicle safely. "I'm stepping out now" is perfectly fine as you open the door. No argument about the validity of the order. No statement about whether the stop itself was justified. You get out, and then you exercise your rights from outside the car. If an officer asks you questions after you've exited, "Officer, I'm happy to cooperate with the stop, but I'd rather not answer additional questions right now." Calm, clear, respectful. Not, "I'm not answering any of your questions," delivered with hostility. That version may technically say the same thing, but it changes the tone of the encounter in ways that don't benefit you. Warm and firm work together here exactly the same way they do in any other version of this scenario. If an officer asks to search your vehicle, "I don't consent to a search of my vehicle." 5 words. You can add, "but I won't interfere if you believe you have authority to conduct one." to acknowledge that you understand the encounter may continue, even after your stated non-consent. That addition matters because it makes clear you're invoking your rights in an informed, deliberate way, rather than trying to physically obstruct anything, while still creating an absolute, unambiguous record that you did not give consent. If an officer asks where you're going or where you've been, I'd rather not answer that question. Simple, direct, warm enough in delivery that it doesn't read as hostile. You don't need to explain why. You don't need to offer an alternative. The refusal itself is complete, and you're not required to justify it. If an officer tells you that refusing makes you look suspicious, I understand that, but I'd still like to exercise my right to decline. This response acknowledges what the officer said without accepting the premise that your rights assertion is actually evidence of anything, and it closes that particular conversational door firmly without making the interaction more adversarial than it needs to be. Let's talk about something that trips people up in a genuinely consequential way. What happens when multiple things are true at the same time? You can comply with an officer's lawful order to exit the vehicle and simultaneously decline to consent to a search. You can step out of the car as required and simultaneously decline to answer questions beyond identifying yourself. You can cooperate fully with the legitimate lawful parts of the encounter and still firmly, politely decline the voluntary parts that you're not required to participate in. These things are not in tension. They're not contradictory. They're simply the difference between the parts of the encounter where you have no choice and the parts where you absolutely do have a choice, and knowing which category each part falls into is the entire point of everything we're walking through here. There's a version of this moment that plays out in a lot of people's heads before they've thought through the rules, a version where saying no to anything makes everything worse, where any assertion of rights is immediately treated as an admission or an escalation, where the path of least resistance is just to go along with everything and hope it works out. And I understand that instinct because it comes from a real place. Interactions with law enforcement can go wrong in ways that are genuinely frightening, and the impulse to minimize conflict by maximizing compliance is a human response to a high-pressure situation. But here's what that logic misses. Giving up rights you're entitled to assert doesn't actually guarantee a better outcome. It just means you've participated in narrowing your own options, often for no corresponding benefit at all. The version of you that exits the vehicle calmly, declines to answer non-required questions politely, declines consent to search clearly, and maintains a respectful but firm position throughout the encounter. That version of you is not making the situation more difficult. That version of you is handling the situation exactly the way the legal framework is designed to be handled, in a way that preserves the maximum number of options for every scenario that might follow. And the calm, warm delivery of each of those choices is specifically what keeps the interaction from escalating, because the goal here is never confrontation. The goal is clarity, your own preserved rights, and a clean record of what actually happened, in case any of it ever matters later. Let's talk about what to do while you're standing outside the vehicle during the stop, because there's a gap between exit the car and stop concludes that a lot of people don't have a clear sense of how to handle. You're standing there. The officer is running your license, or calling in your registration, or doing whatever procedural parts of the stop they need to complete. What do you do with that time? You stand calmly where you've been directed to stand. You keep your hands visible. You don't pace or move around in ways that seem unpredictable. You don't lean back into the car. You don't start going through your pockets for your phone or anything else, without telling the officer what you're doing first. And if you want to record the interaction, which we'll talk about in more detail in a moment, the time to start doing that is as soon as you're settled in place, not in the middle of some other movement that might look like reaching for something else. The reason stillness and visibility matter so much here isn't just about officer safety, though that's part of it. It's also about keeping the encounter as unambiguous as possible. Every movement that requires an explanation is a potential escalation point, and the simplest way to avoid those escalation points is to simply not make unexplained movements in the first place. This is genuinely easier to do if you've thought about it in advance, because in the actual moment, nervous energy wants to go somewhere, and the answer to where does nervous energy go during a traffic stop is nowhere visible for now. Let's talk about recording, because this is one of the most practically important tools available to you in a traffic stop encounter, and one of the most commonly misunderstood ones. In most jurisdictions, you have the right to record your interaction with police during a traffic stop, as long as you're not physically interfering with the officer's ability to do their job. Recording an officer performing their duties in a place you're legally entitled to be, like a public roadway, is generally a constitutionally protected activity in this country. That protection has been affirmed in multiple federal circuit court decisions, and while the Supreme Court hasn't addressed it directly in a single definitive ruling, the lower court consensus is strong and consistent enough that recording a traffic stop is something you should feel entirely comfortable doing. What this looks like in practice, if you have a phone with you and you can start recording without it looking like you're reaching for something alarming, telling the officer calmly, "I'm going to record this interaction," and then doing so is a completely legitimate choice. Some officers will be entirely comfortable with it, some will be annoyed by it. Neither reaction changes your right to do it, and the fact that they're annoyed doesn't mean you have to stop. What you can't do is use recording as an excuse to physically block an officer from doing their job, or to refuse to comply with lawful orders while holding up a phone. The recording happens alongside your compliance with what's lawfully required. It's not a substitute for compliance, and it's not a shield against lawful orders. It's simply documentation of what happens, which serves your interests enormously if the encounter ever ends up contested in any way. A dashcam, if you have one, is doing this automatically already, which is one of the strongest arguments for having one regardless of anything else. A dashcam that captures the entire encounter from the moment of the stop to the moment it concludes is objective documentation that requires zero action on your part in the moment, removes any question about whether you antagonized an officer by recording, and creates exactly the kind of contemporaneous record that can matter significantly if anything about the stop ends up in dispute later. Let's talk about passengers specifically, because the rules that apply to you as a passenger in someone else's vehicle are worth understanding distinctly from the rules that apply to the driver. We already established, from Maryland versus Wilson, that passengers can be ordered out of the vehicle just as drivers can, and the same basic framework applies to your behavior as a passenger on the curb. Comply with the lawful order to exit, decline to answer non-required questions, decline consent to search, stay calm and visible throughout. But there's an additional layer that passengers sometimes don't think about, which is that your presence in the car doesn't make you automatically subject to whatever is legally happening with the driver. If the driver is arrested, that doesn't automatically mean you are. If the driver consents to a search, that consent doesn't necessarily extend to your personal property in the vehicle. Your bag, your jacket, your backpack sitting in the back seat. You have a separate expectation of privacy in your own belongings, and a driver's consent to search the vehicle doesn't typically override your separate right to refuse consent to search your personal items within it. This is worth knowing because it means, even in a situation where the driver is cooperating fully with a consent search, you can still say clearly, "I don't consent to a search of my belongings with respect to your own property." The officer may push back on that. They may argue that the driver's consent covers the whole vehicle. Whether that argument is legally correct in your specific jurisdiction is something worth knowing in advance, because the law on this varies, but the starting point is to assert your separate non-consent clearly and let the legal question sort itself out in the appropriate setting, rather than simply assuming the driver's cooperation means your stuff is automatically included. Let's talk about a scenario that comes up regularly and causes genuine confusion in the moment. What happens if an officer tells you to put your hands behind your back, or places you in handcuffs, even though you don't believe you've done anything wrong, and even if no arrest is formally announced? Being handcuffed doesn't automatically mean you've been arrested in the legal sense. Officers sometimes use restraints during a temporary investigative detention, which is a higher level of restraint than a typical stop, but still technically distinct from a formal arrest in certain circumstances. If you're being handcuffed, this is not the moment to physically resist, regardless of how strongly you believe the restraint is unjustified. Physical resistance to what an officer is doing in this moment, even if that resistance is later vindicated as a response to unjustified force, dramatically complicates your legal situation in ways that often outweigh any benefit in the moment. What you can and should do is say clearly and calmly, "I'm not resisting, but I want to note that I don't consent to this, and I'd like to know if I'm under arrest." That's a complete statement for the record. Am I under arrest? Is a question you're entitled to ask, and the answer to it matters legally. If you're under arrest, you have the right to be told why, and you have the right to an attorney before answering further questions, and those rights need to be invoked explicitly and clearly to trigger their protections. I'd like to speak with an attorney before answering any more questions should follow an arrest announcement as surely as night follows day, and nothing that happens before an attorney is present should involve you answering substantive questions about anything. Let's talk about what happens when you believe the stop itself was unlawful. Maybe you're confident you didn't commit any traffic violation. Maybe you have reason to believe the stop was based on something other than a legitimate traffic reason, whatever the specific basis for your belief is. This is one of the most important things to understand clearly, and I want to be direct about it. The roadside is not the place to litigate the validity of the stop. The place to contest an unlawful stop is in court, with an attorney, using the legal tools built specifically for exactly that purpose, and those tools are genuinely powerful if an unlawful stop actually occurred. Evidence obtained as a result of an unlawful stop can be suppressed under what's called the exclusionary rule, meaning it can be kept out of court entirely, which often fundamentally changes the government's case against you. But none of that machinery works if you tried to argue about the validity of the stop on the roadside, and the encounter escalated as a result. The legal system has a mechanism for dealing with bad stops. It's called a suppression hearing, it's handled by a judge, and it's enormously effective when it applies. The roadside has no such mechanism, and trying to use it as one costs you far more than it gains. So even if you are completely right that the stop was unlawful, the response to that conviction is to comply fully with what's lawfully required in the moment. Say as little as possible, document everything you can, and bring that information to an attorney as soon as the encounter ends. Let's talk about the period immediately after the stop concludes, because I want to give you a clear sense of what to do in those first few minutes once you're back in your car and driving away, because this window matters more than people expect. While the encounter is still fresh in your memory, record everything you can. A voice memo on your phone is perfect for this, because you can do it hands-free while you're still driving and the details are still sharp. What time was it? Where exactly did the stop happen? How many officers were involved? What did they say, and in what order? Did they ask to search the vehicle? Did they state a reason for the stop? Did they show you anything, tell you anything, give you anything? Did you say anything that you want to make sure you remember accurately? The specifics matter because memory degrades quickly, especially when the memory involves a high-stress event. The version of the story your brain tells a week from now is already less reliable than the version it can tell you right now. A voice memo recorded within 5 minutes of the stop ending is as close to contemporaneous documentation as you can get outside of an actual recording of the encounter itself, and if anything about that stop ends up mattering in a legal context, that documentation can be genuinely significant. If you received a citation, keep it in a safe place. If you believe anything about the stop was unlawful, or if you were searched and anything was found, or if you were arrested or detained for any length of time beyond the ordinary stop, these are all situations where talking to an attorney is not a luxury. It's something you should do as quickly as possible, because the relevant legal challenges have timelines attached to them, and those timelines don't pause while you're deciding whether to reach out. Let's talk about a scenario that deserves its own careful attention. What happens during a stop at a sobriety checkpoint, sometimes called a DUI checkpoint, because the rules here are somewhat different from an ordinary traffic stop and worth understanding as its own distinct situation. Sobriety checkpoints were found to be constitutionally permissible by the Supreme Court in Michigan Department of State Police versus Sitz in 1990, on the grounds that the public interest in preventing drunk driving outweighs the brief intrusion of a checkpoint stop, when those checkpoints are operated according to specific neutral procedures and are properly publicized in advance. So unlike an ordinary traffic stop, which requires individualized reasonable suspicion to pull a specific vehicle over, a properly operated checkpoint can stop vehicles without any individualized basis. What this means for you at a checkpoint: you are in a somewhat different position than at an ordinary stop, because the authority to stop your vehicle exists under a different legal framework. You are still not required to answer questions beyond what's required for identification in your state. You are still not required to consent to a vehicle search. You are still entitled to remain silent as to anything beyond what's legally required. The order to exit your vehicle, if given at a checkpoint, still carries the same authority it carries at any other stop. What changes is the threshold for the stop itself having been valid, which is lower at a properly operated checkpoint than it is for an ordinary individualized traffic stop. One thing worth knowing specifically about checkpoints: in most states, advance notice of checkpoint locations is publicly required, and in many states, there are legal ways to avoid a checkpoint by turning around before reaching it, as long as you do so legally and without committing any traffic violation in the process. Simply turning around before a checkpoint and following all traffic rules while doing so is not by itself grounds for a stop in most jurisdictions. Whether this is information you want to act on is entirely your own call. It's simply worth knowing that avoiding a checkpoint legally is generally not the same as doing anything suspicious or giving an officer any basis to pursue you. Let's talk about a situation that trips people up specifically because of the emotion involved, a stop that you genuinely believe, based on what you know about yourself and your circumstances, is happening because of racial or other bias. This is an area where the legal framework frankly has significant limitations, and where the gap between what the law theoretically prohibits and what it's practically able to address in the moment of a roadside encounter is large and real. An officer cannot legally stop you based solely on your race, national origin, or other protected characteristics. That's clear. But the standard for proving that a stop was pretextual in the sense of being actually motivated by bias rather than a stated traffic reason is an extremely high bar in the legal system, one that rarely gets cleared without substantial evidence and careful litigation. What this means for the encounter itself, the same framework applies, and the same tools work, regardless of whether you believe the stop is pretextual. Comply with the lawful order to exit the vehicle. Decline to answer non-required questions. Decline consent to search. Document everything you can afterward. Speak with an attorney about what happened. These are the tools that work, and they work precisely because they don't require you to resolve the question of the officer's motivation in the moment. They simply preserve your rights and your record, regardless of what that motivation was. What it additionally means is that the contemporaneous documentation we talked about earlier takes on even greater importance in this scenario. The specific words used, the specific sequence of events, the specific officers involved, the exact time and location, all of that matters more, not less, when you have a basis to believe the stop itself was improper, because the documentation is what any legal challenge is built on, and challenges built on strong documentation are considerably stronger than challenges built on memory alone. Let's talk about something worth addressing head-on, because it's a tension a lot of people feel in this specific topic that doesn't quite resolve itself through pure legal discussion. There's a version of this conversation where focusing entirely on your rights in a police encounter feels like it's in tension with some broader social or civic duty to cooperate with law enforcement as a general matter. Like knowing your rights and exercising them is somehow at odds with being a responsible member of a community where law enforcement serves a legitimate function. I want to address that directly because I think the tension is less real than it feels. The rights we've been discussing throughout this video weren't created to make law enforcement's job harder, or to enable wrongdoing, or to treat every police officer as an adversary by default. They were created because the founders of this country understood, from hard historical experience, that power without constraint produces abuse, and that the appropriate constraints on governmental power are built into the law itself precisely so that individuals don't have to rely on the goodwill of the specific officer in front of them to determine what their rights are. Those constraints protect everyone, not just people who've done something wrong, not just people who distrust law enforcement, not just people who've had bad experiences in the past. They protect everyone, as a structural matter, because that's how constitutional rights work. And the officers who are doing their jobs correctly, who are conducting lawful stops for legitimate reasons and following proper procedures throughout, lose nothing when you assert your rights. A lawful stop doesn't become unlawful because you didn't consent to a search. Legitimate probable cause doesn't disappear because you decline to answer questions. The assertion of your rights during a lawful encounter changes nothing about the legal validity of that encounter. What it does is make sure that in situations where an officer is overstepping, that overreach doesn't go unchallenged simply because you didn't know you had something to challenge. That's not adversarial. That's the legal system working exactly as designed. Let's talk about practical preparation, because there's a meaningful difference between understanding these principles when sitting somewhere calm and actually being able to access them when you need them under pressure. The gap between knowing and being able to use what you know in a high-stakes moment is something preparation closes, and preparation for this specific scenario is genuinely simple. Practice saying the key sentences out loud. This sounds slightly silly sitting here reading about it, but there's a real reason it works. Your brain stores things you've practiced in a more accessible way than things you've only read. I don't consent to a search of my vehicle. I'd rather not answer questions right now. Am I under arrest? I'd like to speak with an attorney. Say those 4 sentences in your normal voice, calmly, in your own living room, and they will come to you significantly more naturally in the moments where you need them than if you're trying to remember them for the first time under pressure on the side of a road with lights flashing and adrenaline running. Know your state's identification requirement. In stop and identify states, you're required to provide identifying information when an officer has reasonable suspicion of criminal activity. Know whether your state is one of them, and know what that requirement actually includes, because in many states, it's your name, and that's it. A quick search for your state's stop and identify statute will give you a clear answer, and knowing that answer before it matters is exactly the difference between hesitating and speaking clearly. Know how your state's law treats recordings of police encounters. In most places, recording is clearly protected. In a small number of places, the specifics are somewhat more complicated, particularly in states with two-party consent recording laws, though even those laws typically have exceptions for recording in public places where no reasonable expectation of privacy exists. Knowing the rule in your specific state in advance means you're not trying to remember it during the encounter. Have the name and phone number of an attorney saved somewhere accessible on your phone. You don't need to be planning to be arrested to have this information ready. You have your doctor's information saved, and you don't plan to need it in an emergency either. The presence of an attorney's contact information in your phone costs you nothing and is immediately valuable in any scenario where the encounter goes somewhere you didn't expect. Let's bring the whole framework together one more time, because I want to leave you with the complete picture, sitting clearly and simply in your mind, rather than a series of separate rules competing for space. A police officer can legally order you out of your vehicle during a lawful traffic stop. That ruling comes from the Supreme Court itself, from Pennsylvania versus Mims, extended to passengers in Maryland versus Wilson, and it is not the starting point for a debate on the roadside. You exit the vehicle calmly, slowly, hands visible, narrating any movements you need to make, and you take your place on the curb. That's the required part. Everything after that is governed by a different and equally important set of. Before I let you go, I want to say one more time that understanding your rights clearly isn't a small thing, even when the specific topic feels minor on the surface. It's the difference between navigating a real situation with confidence and navigating it with anxiety and guesswork. And that difference matters more than people usually realize until they're actually standing inside a moment where it counts. Thanks for spending this time building that understanding with me today. I'll see you in the next one.